right, good afternoon. Thank you for joining our webinar today on legal cannabis in the workplace. My name is Laura Pfeiffer, and I am a shareholder here at Winthrop & Weinstein, and I'm going to be presenting along with my colleagues today. I co-chair our employment group along with Mark and regularly advise on issues relating to drugs in the workplace and drug testing and all sorts of related issues. But I will let Mark, Rachel, and Heather, maybe starting with Rachel, introduce themselves briefly, and then we'll get started.
Good morning, everyone. I'm Rachel Brigger. I'm also an employment law attorney here at Winthrop that practices in our employment counseling group, and I also regularly advise on a variety of employment law issues, including drug and alcohol testing and drug use in the workplace.
All right, Heather.
Good afternoon, everyone. I'm Heather Bredesen, a counsel attorney also in the employment group here. Part of my practice also includes advising on drug and alcohol testing policies and among other employment law issues. Thank you all for being here.
Good afternoon, everyone. I'm Mark Pyhart. I'm a shareholder at Winthrop & Weinstein. I have been practicing employment law for about 27 years now, most of it with Winthrop. And I am very excited to be presenting on this topic this afternoon. There are definitely some high stakes involved with this topic.
So Mark had said that like whoever works in the most topical puns to their segments, might get a prize. And I said I wasn't quite prepared for that, and he called me a drag. So see, I've already got one. So, all right. So the way we're going to move forward today is sort of like a panel discussion. We're going to have a little bit of a back and forth. And if you have questions, you can put them in the Q&A. We'll do our best to get to them. We have a lot of content to move through today, so we'll see how much time we have for that, but we certainly will give that a try. All right, so we're going to break out our presentation today into 4 different areas. I'm moderating and kind of asking some questions throughout, but it's going to be broken into these 4 areas. So an overview of the law, employees and cannabis use, both hiring, testing, and responding to situations in the workplace, updating your policies and procedures. What should you really be doing as this comes into effect in August? So what are some tangible things that you can think about doing after this webinar that would put you in a better position to deal with these issues in the workplace? Obviously, the legislation with respect to cannabis is brand new, and there's all sorts of different areas of it. Our presentation is going to be focusing on the intersection with that in the workplace. But we will start with Rachel, but I will kind of start with just a spoiler alert to some degree. So I can tell you that nothing today that we're going to tell you means that employers need to permit people to possess, use, or distribute cannabis products at work. So that is something that you can regulate and say that that is not something that you can have present in the workplace. You need to take some steps to make sure that you're covered with that, and Mark will kind of go through that at the end. And the other thing that is kind of a spoiler alert is that there's nothing with this new law that requires employers to allow their employees to be under the influence at work. So I know there's been a lot of questions about what that looks like, and especially with some things that Rachel's going to talk about with the lawful consumable statute. But those are kind of just to level set at the outset. That is something that is clear and is a takeaway from this presentation. All right, so Rachel, do you want to get us started?
Absolutely. So we thought it would be helpful before we get into the details of all the employment provisions of the new law to just give a general overview of the new bill. So HF 100 was signed into law by Governor Walz on May 30th, 2023. And with this bill, Minnesota became the 23rd state to legalize cannabis for adults who are 21 and over. Adults who are 21 and over now can possess and transport up to 2 ounces of cannabis flower in public and possess up to 2 pounds of cannabis in their own residence. The law also establishes the Office of Cannabis Management, which will regulate cannabis and then also develop regulations regarding how and when businesses can participate in the cannabis industry. It establishes and provides a framework for the cannabis industry. It also creates the Center for Cannabis Research at the University of Minnesota, which will investigate the effects of cannabis and their use on health, as well as the prevention and treatment of substance abuse. The new bill also reworks the criminal code to account for legal cannabis, and it treats it now more like alcohol. So it eliminates that criminal liability for lawful use of cannabis, and then also defines certain prohibited conduct like driving while impaired or hunting while impaired. So throughout this presentation, we'll kind of talk about how cannabis is treated more similarly to alcohol use now that it's been made legal. And then finally, obviously, the main topic of this presentation is HF 100 made changes to Minnesota laws regarding drug testing as it relates to cannabis, and also provided certain parameters and rules regarding employer responses to cannabis use in the workplace. So that was the overview. Now we'll move on to employees and cannabis use. So again, just for a little bit of a higher level summary, so you can have a little bit of structure here. Cannabis is now considered a lawful consumable product under Minnesota laws. So it reclassified that from an unlawful product potentially to a lawful product and made that clear. One thing to keep in mind, though, is that cannabis is still considered a Schedule I drug under federal law. So if you have employees that are covered under any federal contracts or who are drivers that would be subject to the Department of Transportation rules regarding testing for commercial drivers, those laws are unchanged by Minnesota's changes in law. So you will still need to comply with those federal requirements. The law also changed the definition of drug under the Minnesota's Drug and Alcohol Testing in the Workplace Act. And we'll get into that in further detail also as well. So continuing on, we're going to address the legalization of cannabis in 3 separate sections. So the first would be pre-employment. And generally, this new law prohibits lawful cannabis use from adversely affecting employment candidates. So if you use it outside of work, you can't consider it with respect to applicants for employment. During employment, we're going to address workplace testing and cannabis, drug, and alcohol testing policies, as well as work rules that would affect what employees can and cannot do during working hours or on company premises or while performing company business. And then finally, obviously, we'll address issues regarding terminating employment and what circumstances and information or evidence you would need or want to have to terminate an employee's employment based on cannabis use in the workplace.
Okay, Rachel, so I know you're going to talk to us about how the lawful consumable product statute has been revised, but can you tell the people that are part of the webinar, like, what is this statute in the first place? And then is it something where we've regularly counseled about it, or it's kind of come up in employment situations prior to this revision?
Sure. Yep. So Minnesota has a lawful consumable product statute. Several other states have similar statutes to this. And what the statute basically says is there are certain products that employees can use that employers cannot discipline or discharge them for that use. And like you asked, this does come up actually pretty frequently. So a common situation, which we will regularly hear from clients, is I have an employee who we saw at a bar, or another employee saw them and they got overly intoxicated. We think that reflects poorly on our company. Can we do anything about it? And in most purposes, you can't. And it's because of this statute, because the use of alcohol is a lawful consumable product, and it was outside of working hours and off company premises. So the statute has been around for a while, and it's something that does get used. And so here's how it has been revised. So previously, cannabis wasn't called out specifically as a lawful consumable product. So there was some confusion as to whether it would be considered in that manner since it was still unlawful under federal law and only lawful in Minnesota to a degree. But the law has made clear now that cannabis is a lawful consumable product and that employees are protected with respect to such lawful use of cannabis as long as it takes place off the company premises and outside of working hours. So again, the law also clears up that if federal law would consider it to be unlawful, that employers can still take action based on that. We still have that federal law exception. And then it also provides these protections for employer action, which you can see here on this slide, that it said employers can still discipline or discharge an employee for cannabis use, possession, impairment, sale, or transfer during working hours on work premises or while operating an employer's vehicle, machinery, or equipment. So that's again what Laura, introed with, that nothing here is changing your ability to discharge or discipline an employee for that use during working time, or if a failure to discipline or discharge that employee would violate federal or state law or regulations or cause an employer to lose that monetary or licensing related benefit.
Yeah, so you will still have the ability to take action on that. And Heather will talk a little bit more about kind of the prior to termination piece of it. So kind of during employment, how that would be evaluated and kind of what steps you need to take to shore up your ability to do that. And then Mark will be talking about how that looks like in the termination setting. So sort of as a catch-all, the consumer product statute did say that you still have the ability to do that, but there are things that you need to make sure that you want the latitude to do that. All right.
Great. So
Yeah,
now,
right. So just one thing I was going to ask you, just to again level set things for the participants, Rachel, is so you're going to talk to us about testing and what that looks like and how this changes the ability to test. But I know a lot of our clients have been talking to us about how tight the labor market is and how challenging it is to find employees. And so I guess maybe to just back up a second, like as a general matter, do employers need to test their employees, or like what's your thoughts about that question?
Sure. So no, you absolutely do not have to test your employees. It's not a requirement. Well, unless it is under federal law, but generally it's not. But
right. But generally speaking, no, right?
Right. Yeah. But if you do test, you do have to follow the rules under Minnesota law. And like you said, because of the tight labor market, many of our clients are choosing not to test. But again, if you do, you need to follow Minnesota law. So Minnesota law generally has a very strict drug testing statute. It's called Minnesota's Drug and Alcohol Testing in the Workplace Act. And it was enacted about 35 years ago, and it only allows testing in certain circumstances. And if you are going to choose to test, you have to do it only pursuant to the requirements of the statute, and you have to have a written policy also that complies with the terms of the statute. So the big change here with respect to cannabis, and this is one of the big takeaways, is now you can no longer do pre-employment drug cannabis testing. You can no longer do testing for cannabis for pre-employment. The statute has changed the definitions of drug and alcohol testing to carve out and create a new category for cannabis testing. And pre-employment testing is limited to drug and alcohol testing. Therefore, no more pre-employment testing can be done for cannabis. And go ahead. Yeah.
A few exceptions to that we'll kind of go through, right? But just as one kind of big takeaway here is that, people need to be aware that just including the same panel that you've always done for your pre-employment, or we had a question from a client this week that they said, well, we place people at clients and the clients have that requirement, right? But, all of those things that need to be reevaluated and relooked at, because unless one of the exceptions applies, that there is a pretty clear restriction on the ability to do pre-employment testing for cannabis, right? All right.
Yep.
Go ahead, Rich.
Yeah, so you can move to the next slide. I think, like we just said, no more pre-employment testing for cannabis. There are certain exceptions to this for certain positions, and unless testing is required by federal law. So you'll see in the next slide, we've set forth some of these exceptions. And the biggest one, which everyone is dealing with, is, well, most common to be dealing with is safety sensitive employees.
Yeah, so one question on that, because I know a number of us have got questions from clients about this, is, is it a possible workaround, Rachel, to just call all of your positions safety sensitive, or to like classify a very broad group of people as safety sensitive? Is that a possibility? Or, what's our recommendations about that?
Yeah, so that's something that has come up a lot because this is a main exception, but generally classifying just a really broad group of employees as safety sensitive isn't a good workaround. We think you really need to be thoughtful about which employees you do classify as safety sensitive. So if it gets challenged, you're able to support it based on those employees' regular job duties. And this is an area too, where because we don't have a lot of information beyond this definition of safety sensitive, we're anticipating that maybe there will be some additional guidance provided as to how to classify employees as safety sensitive, or maybe even examples of employees that might likely be considered as safety sensitive. So again, although it hasn't been tested yet, we think it will likely be evaluated with a high level of scrutiny. So if you are considering classifying employees as safety sensitive and pre-employment testing them for cannabis, it would be best if you have some solid support for why they would be considered safety sensitive employees.
Yeah, so
And
one
then-
thought on that is to, actually look at the job description. So,
Right.
maybe there's parts of the job descriptions that are pretty clearly safety sensitive, but to really, think about that and have the safety sensitive part of that kind of dovetail with the job description itself, or, and a lot of our clients have job descriptions that have sat around for years and years and maybe really don't bear a relationship to what the job is anyway. So it might be a good opportunity to dust those off. And if it really is safety sensitive, to add kind of components to that would support that.
I think that's a good point, Laura, that you just made also, because I've seen that time and time again where the job description doesn't actually fit with what the employee is actually doing. So it's a good time to go back and look at what they're actually doing, see if the job description is consistent with that, and then take a look at this definition of safety sensitive, keeping in mind what Rachel said. It's probably going to be looked at with some certain level of scrutiny.
Yeah, and then we are, like Rachel said, looking to see if there's other guidance that comes out, or frequently asked questions, because I do know that a lot of us have got questions about the safety sensitive piece. So.
Yeah.
All right, anything else to add on this one, Rachel, or?
No, this is, you can see the remainder of the exceptions on the slide. They're less likely to be applicable, but another one could be this positions with face-to-face interactions with vulnerable groups. So if you have any questions regarding that, we're happy to discuss it further. But
So we
otherwise,
just had a question come in on this, and this is a really interesting question. I'm not sure we're going to have the answer, but I'm gonna raise the question because this is the first time I've seen this particular question as it relates to safety sensitive. So here's the question. Am I correct in understanding that safety sensitive relates to physical safety, not financial safety? So in other words, think of somebody who is in an accounting position or holds a certain position within a financial institution. I will say that everything I've read so far in the new cannabis legislation talks in terms of the welfare of the individual coworkers or the general public. And it's almost always, when you look at the different positions that are specifically identified, it almost always equates to physical well-being or safety. But I think this raises a really good point of, could this also be somebody who is in a position where they could cause harm financially to somebody else? And I don't know that we're going to have the answer now. I think that's something that could be flushed out once we see some case law and interpretation on this statute. And I don't know if Laura, Rachel, or Heather, if you have any thoughts on that also.
Yeah, so because Heather isn't part of there's a different part of your segment that talks about safety sensitive, where that it's already part of kind of the analysis. And I think the presumption that is physical kind of safety, like kind of you're driving the forklift and you could hurt yourself or others, or, sort of as your typical example. But I mean, is that fair, Heather, from kind of what you were reading on your portion?
Yeah, that would be my current understanding as well, that it relates to physical safety as far as the types of job duties that are involved for falling under safety sensitive. And other states and federal law also involve similar definitions of safety sensitive positions. So I think looking at those as well could offer some additional guidance.
Yeah.
But I mean, good question. And like Mark said, there's a lot more to follow to see whether there's other guidance that we get. And we'll be carefully following this and, following up with clients and attendees as we get more information.
And sorry, I have one more question. I've got a few questions now on the safety sensitive piece. And I think this one is interesting also. The question is, does any supervisor mean any supervisor, period? Meaning if they're a supervisor, they're safety sensitive, or is it somebody who is a supervisor in a safety sensitive position? I have thoughts on that.
Yeah. Also, what's your preliminary? I mean, I'm reading it too, right? To see, yeah. Right? But so what's your?
Yeah, my thought is it's got to be supervisory position, and it also has to be, they have to be in a position where it would, their job duties would threaten the health or safety of somebody else.
Yeah, I think that's how I would read it.
I would agree with that.
And then
all right.
one final comment and note on this before we move on. There's a comment that somebody made, asking whether it's true that all healthcare providers, in other words, doctors, dentists, nurses, pharmacists, they're kind of de facto safety sensitive. I would answer that as yes. I think that would be a fair interpretation, if not an exact interpretation of the definition of safety sensitive under the new legislation.
I think so as well. All right, well, should we move on? But thanks for picking those up, Mark, because I think it's nice to address things kind of as they come in, especially right when we're talking about them. So to get people's questions answered if we can. All right, so now we're going to turn it over to Heather, and she's going to talk to us about some of the rules that relate to kind of what happens during employment. So, kind of focusing. So now the person's been hired. You either tested them or you didn't, depending on, kind of how the rules shook out and whether they were safety sensitive or not, or met another exception on the cannabis. But so now they're with you. So what things do you need to be thinking about now?
Right. So one large difference between cannabis and alcohol, which is another lawful consumable product, as Rachel mentioned, is that technically speaking, all a cannabis test can determine is if a person has used cannabis within the past 12 hours to up to 90 days, depending on which bodily substance is tested. There's no currently available test that can measure the level of person's impairment from cannabis right at that time. So THC is typically detectable in someone's hair sample, for instance, for up to 90 days, in urine for a month or longer. Saliva testing is a bit better and can detect THC for only up to about 24 hours after actual use. And blood testing can detect it for up to 12 hours after use. So if you do test an employee for cannabis and their test comes back positive, due to the way testing currently works, the employee could possibly claim that they used cannabis lawfully outside of work days ago, or maybe the night before, but that they were not actually impaired at work. So one consideration, if your company does still want to continue cannabis testing for current employees, it could be wise to consider what bodily substance is going to be sampled and keep up to date on, the technology as it hopefully continues to evolve.
Yeah, so the science just hasn't really caught up yet, right? So I mean, it's much easier with alcohol because if you send somebody, you can get a true indication as to whether they were impaired when they were working, right? So, but as Heather explained, there's all these different pieces on this. I was actually listening to NPR last night and they said that they were beta testing a different test. And so, hopefully there will be something that gives employers a more clear indication soon, but it's kind of more to follow on that.
Right, and maybe why cannabis has kind of its own carve out in the statute, and it seems to have a bit more protection for cannabis use versus other lawful consumable products. Just it could be due to the nature of the testing currently available. So one important piece to remember as part of this new legislation is that even though cannabis is now a lawful consumable product, employers are still permitted to establish written policies prohibiting the use, possession, impairment, sale, or transfer of cannabis during work hours, on company property, or while the employee is operating the employer's vehicles, machinery, or equipment. If a company does not have a written policy, it cannot take adverse employment action against an employee for cannabis use. The statute itself does not have any rules regarding employee cannabis use at work. So it's very important for employers to establish their own work rules and have these written and distributed to employees.
Yeah, so I think this is another one that, if you're eating your lunch and, like, what should I pay attention to? This is a big one, right? So because a lot of our clients, and there's, who you are if you're on this call, but like are anti-policy, or they're like, we don't want a handbook, or, then that's just something else we have to follow. But at the same time, I feel pretty strongly that most of our clients do not want people to be under the influence at work and then feel like they have their hands tied behind their back and can't do anything about it, if they haven't followed kind of the rules, right? So I think one of the things we want as a big takeaway here is that if you want more latitude to enforce not having people like possess, use, or transfer cannabis at your workplace, that having a simple written rule about it, a drug-free workplace, that it's written correctly to include cannabis, right, is an important thing for people to think about, and obviously is something that we can help people with. So many of you, we've already done your handbook, so it's just an easy revision. Others, if you would like assistance from us, we're happy to help. So, but anyway.
And just to pile on, sorry, Laura,
yeah.
just to pile on that piece of it, because I was going to address some of this also. So
Yeah.
might as well just talk about it now. Yeah, I mean, we have reviewed so many handbooks over the years, and even if you are an employer that has a drug and alcohol testing policy and cannabis policy that complies with DATWA and the new cannabis legislation, I think it's useful to always have a separate policy. And what I've seen is literally a paragraph or two in length, and you can call it a drug-free workplace policy that just spells out your rules with respect to this issue. And for those of you that don't test, but want to control some of these issues in the workplace, then based on what Heather is saying, as it relates to cannabis, you have to have something in writing. So you might as well, put in some type of drug-free, alcohol-free, cannabis-free workplace policy.
Right, and it's important because of the reclassification of cannabis and removing it from the definition of drug in most employment situations, unless one of those exceptions apply. It is important to have cannabis specifically mentioned in your Minnesota employee policies.
Right. So yeah,
So-
again, you're signing up to test everybody just because you do this, right? But it's like, you know, I think we do highly recommend having a policy that complies with the drug-free workplace, like Heather and Mark have just mentioned.
We've got a question that's come in that's, and by the way, for all of our participants, I'm seeing all of your questions. Some of them are very specific to your industry. So those are things that we might need to cover after our presentation. So I'm going to do my best to kind of cover these as we're hitting these different topics. So this question I think is timely with where we're at. Should you have employees sign the policy if you were rolling out a new policy? In other words, suggesting we already had a policy, we're rolling out something new now or making revisions to it. And should we have employees sign that revised policy? Heather, do you want to comment on that?
Sure. So the requirement in the statute is that employees, excuse me, do have to sign an acknowledgement before they are actually tested. It's not required to just have employees sign acknowledgement of reviewing the policy generally. The statute does require having the policy available to all employees. So and having it on your workplace, if you have a physical workplace in a conspicuous area. So, I mean, you don't have to have all employees sign off on the new policy, but it is important to establish that you've probably communicated that there is a new policy and make it readily available to your employees.
I mean, yes, that makes perfect sense. And I would even suggest as kind of belt and suspender approach and as a best practice that if it's easy enough to have them sign, and this is true for almost any material revision to your handbook, if it's easy enough to have employees sign an acknowledgement that they understand the policy or policies have been revised and they've reviewed it, then best practice would be to have them sign it.
Yeah, if the policy is within your handbook, yeah, it's best to, when you roll out the new handbook, have everyone sign acknowledgement of that new handbook.
Yeah, but I mean, I think just to pick up on what Mark was saying is that maybe you're, well, and I mean, number one is that there's probably some things to be updated with your handbook generally, right? It depends on the last time you kind of looked at it, but many times there's maybe more than just this issue. And so it would make sense to roll out a new one. But maybe you just did it, right? And so the only thing you need to change is this cannabis policy. Then best practice would be to get a sign off on that if you can. So, and then if you're testing, you know, I know Rachel talked about how Minnesota has such a specific policy. What we really recommend there to ensure that it's clear that the employee saw that and acknowledged it is that it's attached to the offer letter, right? So that, because but when it's pre-employment, they're not getting your handbook yet, right? So if that's kind of where it is, if that's not a practice you have already, that's a good idea to do so that you have proof that they had the drug testing piece of it as part of the offer of employment.
So I have another question that I want to throw out to the group. And Heather, I think you're about to get to some of this discussion. So I think it's timely. The question is, how do you separate medical use? And we get this question all the time now. And, you know, that's what's really unique about this new cannabis legislation. Because before this legislation went into effect, we already had legalized medical prescription use. That's obviously still there. What we're talking about with cannabis use, though, is there's kind of this threshold question of whether somebody is using it in the workplace, possessing it in the workplace, or impaired in the workplace. And it's this impairment piece that really gets to this issue about separating medical use. It doesn't really matter whether it's for medical use or not. you as an employer have a right to address cannabis use, lawful cannabis use by somebody outside of work. If they're coming to work and they're impaired, you have a right to address that. And I don't know if the three of you have any additional comments or thoughts on that, but I guess what I'm saying is I don't think there's really a difference between medical use or not.
Mark, I think you're right on that analysis. There's not much of a difference between medical use or not. If you are tested for cannabis and the test comes back positive, you can still provide your registry certificate as a patient in the registry program as a defense to that, but you still can't use or possess even medical cannabis or be impaired by that at the workplace.
Yeah, I think it's too, just to remind everyone that like there's a process and an application and you have to have a qualifying condition, right? So like employees can't just claim now after August 1 that it's medical without, following the rules that are otherwise required for medical, right? And being on the registry and providing that application, right? So that's the only other kind of caveat I'd add to that as well.
And again, I don't think it matters because you still, as an employer, regardless of whether it's medically prescribed or not, because now it's lawful, but you still have a right to address impairment. And that's where all these other things come into play, the reasonable suspicion and safety sensitive positions and all the other stuff that we're talking about.
All right, Heather, so I think you're maybe not quite done with this one, if I remember right.
No, we can move on to the next slide.
Perfect.
So as we've kind of been discussing, being able to tell if someone's actually impaired by cannabis can be a bit tricky depending on the circumstances, but other violations of employer rules, if they're, as we said, written and distributed, certain violations can be a lot easier to tell, such as possession, transfer, or if you witness an employee, taking cannabis or smoking at work. If you witness someone doing one of those easy policy violations, you find it on their person or in their locker, or you see them smoking outside or while they're working. That's pretty easy. So you can certainly take action against someone just for breaking those rules without even testing the employee. And sometimes that's probably the best way to go, is to just, take those behaviors and discipline or correct that action, without having to go through the testing policy. Other circumstances, as we've discussed, determining whether someone is impaired is a lot more judgment based. And that's where, it takes some observation and more work just to determine if someone might be impaired by cannabis. And that's where reasonable suspicion testing comes into play. I think we can move on to the next slide, Laura.
Yeah, so just like kind of one follow-up on that is, so like one of the things, like as an example we've been providing clients is, since somebody could say that they lawfully used outside of work, and let's say they crash a forklift and you believe that they were using cannabis. The easier way, and probably the more recommended way to address that, is to discipline or discharge for crashing the forklift. So the behavior, like Heather said, instead of like having to worry about like, well, what comes back, and then is there an explanation, or can they say that it was lawfully used outside of work? Maybe the more direct route and the preferred route is to just take action based on the behavior, like Heather said.
Yeah, so it's important to remember that even before this new cannabis legalization was passed, employers were only permitted to drug and alcohol test current employees in 4 specific circumstances. One was routine physical examination testing, and that could be done only once per year, and the employee had to be given 2 weeks written notice that the test was coming. Random testing is the second category. And again, this is only allowed for safety sensitive positions or professional athletes under a collective bargaining agreement. The third type of testing that's permissible for current employees is reasonable suspicion testing, which we'll get into. And the fourth permissible type of testing of current employees is treatment program testing, meaning that if the employee has been referred by the company for substance use disorder treatment or is participating in a treatment program under an employee benefit plan, then the employer can, for up to 2 years following treatment, or following the completion of the treatment plan, do employee drug and alcohol testing for that employee. So the new law affected these particular categories. The new law added that for routine physical examination testing, that is no longer permissible to test for cannabis unless one of those exceptions exists, such as the safety sensitive position or DOT drivers, or the other categories like police officers, firefighters, and face-to-face care, or if required by federal law. Reasonable suspicion testing of cannabis is still permitted, and treatment program testing remains the same as well. And random testing, again, is only for safety sensitive positions or professional athletes. So reasonable suspicion testing is, I would say, the most commonly used type of testing and the one we get asked the most questions about. So cannabis testing and drug and alcohol testing is permitted under the new law if there is a reasonable suspicion that the employee is under the influence of drugs or alcohol, has violated a written policy, has sustained a personal injury or caused another employee to sustain a personal injury, or the employee has caused a work-related accident or was involved in operating machinery, equipment, or vehicles involved in a work-related accident. Oddly, the statute does not technically permit reasonable suspicion testing if there's reasonable suspicion that the employee is under the influence of cannabis. We don't know if this was intentional or if this was a legislative oversight, but that's why it's important to, again, have these written policies prohibiting employees from being impaired by or using cannabis at work.
So Heather, if an employer just has a blanket policy that they're going to test if there's an accident, does that work, or do they need to have some more nuances to that now in light of some of these changes?
Right, so we would not recommend having a blanket policy to test every employee for cannabis or even drugs and alcohol simply because they were involved in an accident. So testing of employees for drugs, alcohol, and cannabis cannot be arbitrary and capricious. So that just means there needs to be a rational basis behind the employer's decision to test. So there has to be at least some reason to suspect that the employee that was involved in the accident was under the influence of drugs, alcohol, or cannabis in order to test them for that after the accident.
And sorry, I just wanted to jump in and just add something, kind of piggyback off something Laura said earlier. When you're talking about an accident, you can discipline based on the conduct, based on the accident. Maybe you've determined that somebody was careless and they caused that accident, and that's something that warrants discipline up to and including termination. And I think it's important to remember that if you do decide to test because you have some other reasonable suspicion related to that accident, if you do decide to test, you're now bound by DAT law and DAT law's obligations. And if there's a positive test, there's obligations to offer up treatment. So it's for the first time. Yeah, exactly. For the first time. So I just kind of, sometimes there's kind of the practical side of all this of, do you even have to test? I mean, obviously, if you do, you're going to have to comply with the statute, but by doing so, you potentially take on more obligations. And this is kind of a question that I see regularly with employers, asking these questions of, should we test?
Right. So, and Heather, do you want, like on the flip side, do you want to talk about the example we talked about, like if something falls on you, right?
Yeah, I mean, just because an employee gets injured doesn't necessarily mean that there's any indication they are under the influence. If, like you're saying, if something falls from the sky and injures an employee, I mean, there's no indication they were doing anything wrong or were behaving in any sort of careless manner, or if, their injury appears to be based off repetitive use like carpal tunnel or some other sort of repetitive use injury that wouldn't warrant drug or alcohol or cannabis testing, for example.
All right. So do you want to tell us about this checklist? Like, so should people be putting together checklists? Like, what does that look like, or how would they use it? Maybe you could explain that to us.
Yeah, absolutely. So for reasonable suspicion testing, it is recommended to have a checklist in place before you need to do reasonable suspicion testing or make the determination that there is reasonable suspicion. And your supervisors and managers should be aware of this checklist and maybe even have undergone training regarding the checklist and what sorts of types of things would indicate reasonable suspicion that someone is impaired or under the influence. So this checklist, it should contain observable behaviors indicating impairment, such as a work-related accident, physical and behavioral indicias of impairment, such as bloodshot or watery eyes, dilated or constricted pupils, nausea, vomiting, poor coordination, disorientation, paranoia, extreme aggressiveness, aggravation, slurred speech, and those sorts of things. And for cannabis especially, this new statute says that adverse action may be taken against the employee when the employee lacks the clearness of intellect and control of self that the employee would otherwise have. So that means that the employee is acting different from how they usually act. So someone determining reasonable suspicion should be familiar with that particular employee's normal behaviors. It should be, the checklist should be filled out by someone that knows the employee and, by someone that can comment on how that particular employee is behaving differently than normal. For instance, it could be beneficial to have two supervisors that both know the employee, observe the employee, and independently fill out the reasonable suspicion checklist. Additionally, if there is an accident or there are other witnesses observing the employee's behavior, it could be helpful just to give extra backup toward this reasonable suspicion if those witnesses give a statement or write down what they observed as well. It's also important. Yeah.
Because a little confusing, like, okay, what am I supposed to do and how am I supposed to manage that? And so Mark will kind of, as he sort of wraps up at the end, talk about sort of to do things. And, and obviously there's ways that we could help on this if, people choose. So, but yeah, I mean, there are some things to kind of document and think about as it relates to that. But I do think this is an area that is a bit murky, like, what does this mean that they lack the clearness of intellect and control that they would otherwise have, right? Like maybe they don't have that much to begin with. Like, I don't know, right? It's a little bit confusing, but Mark will kind of close us out with some things to think about and updates and what have you kind of at the end. So, all right. So Mark, do you want to talk about like disciplining, discharging, like terminating, like what does that look like under this new regime?
Sure. So first of all, thanks, Rachel and Heather. That was great info. That was a lot of detailed info. The good news with all of this is we're kind of asking, we're at the point now where we're asking the question, okay, you know, that's great. We got the new law, but can we still discipline and or terminate? The good news is, yes, you can, but it's, there's some additional hoops that you kind of have to jump through as it relates to cannabis anyway, and that's what we're talking about. There's this threshold question that first has to be asked, and I'm just going to read it because I can never remember all of this. Is the employee using, possessing, selling, or transferring cannabis at work? Or is the employee impaired while working, while on company property, or while operating company equipment? That's the threshold question that you have to ask as it relates to cannabis. Then there are 4 buckets or 4 situations in which, you know, with that threshold question, then there are 4 situations where you can take action. And somebody asked a question that I think is spot on that I'm going to kind of use as an example. The question is, what if the employee comes into the work area strongly smelling of cannabis? Well, cannabis is legal. They could have been outside smoking cannabis off work property, and, you know, that's legal. So just because they smell of cannabis isn't enough. But go back to that threshold question I was just talking about. We don't have evidence that they're necessarily using, possessing, selling, or transferring in the workplace, but we might have evidence that they're impaired in the workplace. So, okay, maybe. We've got a maybe. So let's go to bucket 1 of the 4 buckets, these circumstances. And I have to laugh too at the language in the statute, because I think it's interesting language and really hard for employers, for anybody to figure out. So bucket 1, the employee lacks the clearness of intellect and control of self that the employee would otherwise have as a result of consuming cannabis. So this, if you recall, you know, what Heather and I think Rachel maybe touched on this as well, it's, you have to have this baseline now, and for employees. And I've kind of equated it to, for all of those who are out there who are parents, who we went through this concussion protocol when our kids were playing organized sports, and you had to have this baseline test so that then you could later determine if your kid got hit in the head, whether they had a concussion. So now it's kind of like that, where in the workplace, all of a sudden you have to have this baseline test of your employees so that you know what non-impaired behavior looks like, not just for any employee, but for that employee. So that's a big burden for employers for sure. So now, you know, again, you've got this question, somebody comes into the work area and they smell of cannabis. Do you have any evidence or reasonable suspicion that they're consuming cannabis at work? Well, what if in addition to they smell of cannabis, and this is a common question or scenario that we get all the time, coworker comes into HR and says, hey, by the way, I was just walking through the parking lot on the way back from break, the company owned parking lot, and I saw so-and-so sitting in his car smoking what looked like a joint, and it smelled like marijuana. Okay, now you've got some real reasonable suspicion. You've got some stuff going on here. And now you're going to observe this employee when he comes back from break to see if his behavior is impaired. And I'm going to add, because I know someone's going to call me out on this. Well, if you caught him smoking cannabis on company property, even if it's in the parking lot, you can take action. Absolutely. You absolutely can. You don't have to test or anything. The issue is we don't know yet. We don't know what it was.
Your work rule says so, right?
Right, exactly. Because your work rule says so, because you did the drug-free workplace policy. So I always think as a best practice, the first step is to just simply ask the employee. So they come back into the workplace, and if you want to ask them, hey, were you out in our parking lot smoking cannabis? Yes. Okay, you're disciplined, and that could be termination. Because again, as Laura pointed out, you got a policy that says so. But what if they say no? Well, you can certainly observe their behavior, and if it's different than their baseline, then you can take action. Absolutely. You absolutely can. You don't have to test or anything. The issue is we don't know yet. We don't know what it was. then that might be enough to take action, okay? And as I said, even if you're that employer that doesn't want to test, just make sure you have some type of policy in place that says you can't use or possess on our property. So that's bucket one. Bucket two, let's just use the same hypothetical that you've got somebody sitting out in the parking lot. Bucket two is you've asked them, you've called them out on it to see if they're going to fess up, and they don't. And you've got reasonable suspicion now because you've got a credible coworker who saw it, and maybe you've got some bloodshot eyes. Remember all the stuff Heather was talking about. You've got some of these other facts playing in here. So you test. And that's your right as long as you have a written policy that complies with DATWA, including a written policy that now complies with the new cannabis legislation. And again, as I mentioned before, just remember, if they test positive and it's a first time, you may have to offer treatment. Okay, so that's another situation where you could discipline. Bucket three, they violated your work rule. Again, as Laura pointed out, if you have solid, credible evidence that they possess or are using cannabis in the workplace, it doesn't matter. They're done. You have the right to discipline, including terminate, because of that act alone. And then finally, you've heard us talk about this too quite a bit this afternoon, and that's bucket four. You are required by law, state or federal law, to act. And the most obvious example there, and there's a whole bunch I could give you, but we're short on time. The most obvious one is an employee who is subject to DOT regulations. But it could also be somebody that's in a safety sensitive position. All right, so those are the four buckets. I apologize, I'm going so fast, but we are very short on time. Those are the four buckets under which you can take action, including termination. And now I just want to spend a quick recap on kind of what the takeaway is from all of this. So one, first and probably foremost, review and revise your drug and alcohol policies. As we mentioned before, even if you decide you're not going to test, make sure you've got a drug-free workplace policy that specifically spells out alcohol, unlawful drugs, cannabis, and abuse of prescription medication. You want to make sure it spells out all of those. Two, if you are testing, make sure again that you review and revise your written policies to make sure it complies with DATWA for all Minnesota employers, and also complies with the tweaks that you have to now make because of the new cannabis legislation. As Rachel talked about, no pre-employment testing unless it's for one of those safety sensitive positions or you're required by state or federal law. Again, distinguishing unlawful drugs from cannabis. And as Heather pointed out, revamping your reasonable suspicion language to make sure it's clear. Another takeaway, implement training for reasonable suspicion. This is perhaps one of the biggest things that employers need to do in light of this new legislation, is to take the reasonable suspicion piece seriously. Make sure you have employees that are trained on that process. Also, real quick, we talked about reviewing job descriptions and, more importantly, job duties, making sure that the job duties sync up with the job descriptions, and where it's appropriate, classifying people as safety employees as safety sensitive. Another good one, I think, is when you are engaging in some type of reasonable suspicion documentation, making sure that you have two people involved so that there's always another witness there. And then finally, establishing that employee baseline that we talked about. I know that's going to be very cumbersome and a burden for employers, but if you're able to establish that baseline, you're going to have something to compare behavior against. So that's all I have. Please let us know how we can help. And Laura, I'm sure you've got some closing comments.
Yeah, so I mean, the one thing, just as one follow-up, is that we are able to help with a reasonable suspicion checklist and training, and so that's one area where we have developed some things that we can work with clients on if that's something they choose. So I think it was great. We were able to get to a lot of the questions kind of during the presentation. So it wasn't just at the end, sort of, in the flow as we were talking about the areas, but
It was a joint decision, Laura.
it was a joint to see. I'm very disappointed at Mark's lack of effort there.
I didn't have enough time.
Oh, I see. We shortchanged him on time, so he had to focus on his content instead of his puns. So maybe next time. So I guess we didn't take our assignment there very seriously. But we do. Mark and I very much appreciate Rachel and Heather and all of their help with this presentation, as well as summer associate Mike Petchel helped with our slides. He's with us this summer and helped with that, which we appreciate. And then we just want to thank everyone for attending. So we hope that you found it to be helpful, and we appreciate you spending an hour with us this afternoon. So, all right, well, with that, I think we can close the webinar, but unless anyone has any kind of final comments, but otherwise, a big thanks to everyone.
Thank you.
Take care, everyone.